Welcome everyone to Taylor House and to our event, Careers in International Arbitration. We'd like to welcome our panelists. Susan Carmine, Dean of HW, will introduce them individually. Just a few words about the society. We are a 108-year-old organization. We have members from different countries around the world. More information about the membership and how to join is at www.asil.org. More information about the Holtzmann Center that's sponsoring this event is also available there. And on your chairs, you'll find some information about upcoming events. And if you have any other questions, feel free to stop by and ask me. And I think we'll just start because we're kind of running late. So, Susan?
Great. Thank you so much, Georgia, and good afternoon to everybody. And let me also echo the welcome to Taylor House, the headquarters of the American Society of International Law. We're delighted to convene this panel to have a discussion about careers in international arbitration. I would like to thank the American Society of International Law, the Holtzmann Center for International Arbitration and Conciliation, as well as the new professionals, the Society's new professionals interest group. Georgia, thank you so much for your help in putting this session together, as well as Lisa Werner, who's here. Lisa is on behalf of the new professionals interest group. We're delighted that you have taken time out on a Thursday evening to be with us, to have a conversation about careers in international arbitration. 30 years ago, if we had such a panel, it probably would have been 2 or 3 panelists talking to people, a few people whom they knew, and it was a very small group, and they probably had a pretty limited view of the subject matter. 15 years ago, we probably would have had more people in the audience. The topics that would have been on the agenda were the emergence of this concept or the development of investor-state arbitration, increased focus on commercial arbitration, and then probably an audience that was still quite small and perhaps also fairly uniform in their education and their approach to issues and the like. Fast forward now to 2014, and we have today an audience full of people that are many people well versed in the subject of international arbitration. At law faculties around the country, the subject is being taught. We have institutions that didn't exist many years ago, or if they were fairly dormant, and they're very active in managing arbitrations, providing assistance to arbitrations. And those institutions also include the lawyers, the law firms, and individual lawyers that are heavily involved in this practice. So it's within this spirit of a field in law that is dynamic, that is changing, that we convene our panel today to talk about careers in international arbitration. And we have gathered 4 individuals who work in the field and work in a variety of different areas so that you can get a sense of their the responsibilities, and also we're going to have a little discussion at the outset of how they got to where they are. I'm going to very briefly introduce them because you have the bios in the package, but right to my left, to my immediate left is Daniela Arguello, who is a legal counsel on the institutional matters team at the International Center for the Settlement of Investment Disputes, ICSID, and she's originally from Costa Rica, and also my former student, if I may say. And then to her left is Jeremy Sharp. Jeremy is the Chief of Investment Arbitration. There's noise in the audience, but that's okay. But Chief of Investment Arbitration in the Office of the Legal Advisor at the U.S. Department of State. And in that capacity, he represents the United States in investor-state and state-to-state disputes. I'm glad you could be here. And then to his left is Victoria Shannon, who is professor at Washington and Lee University School of Law. Her work is in the area of arbitration, and in particular she's looking at third-party funding, but she had previously worked at the International Council for Commercial Arbitration, the ICC, as well. So Victoria, we're glad that you're able to be here. And then also Juan Felipe Merizalde, who's an associate at Deckard, where he works in international dispute resolution, a native of Colombia. And we're glad that you're here as well. So we deliberately structured the panel in a way so that we would have the perspective of somebody working in investor state from the institutional side, from counsel side, somebody who has worked in the commercial area, and then also somebody who may be straddling both the International Chamber of Commerce commercial side with Juan Felipe, as well as perhaps even some investor state. So we have a dynamic group, and what I propose to do is to launch this with just teeing up the question, okay, to get a sense of careers in international arbitration. Daniela, how did you get to where you are? And I'm going to ask this question, I'm not going to repeat it again to all of the panelists, but how did you get into international arbitration?
Well, yeah, first, thank you for being here. Initially, my first job, I come from Costa Rica, and the Center of International Arbitration and Conciliation was mainly in arbitration but commercial. And then after I just began an interest in it, and after law school, I decided to pursue my LLM here at GW, as Professor Carmine said. And then after my LLM, there was an opportunity open at ASIL, which was one of my main areas of interest, and I took it at the time. It was a short temporary consultancy, and then afterwards another opportunity with it opened, and then that's how today I became legal counsel, and I think that's it.
Okay, great. So you had an interest in the topic before arriving here.
Yes, exactly. Back home, we don't have, law school is very different. I only had like one ADR course in general. I didn't have specific courses like we do here in the LLM that I took during the LLM. So I wanted to expand, but also before coming to the LLM, I did a year before a course in Introduction to U.S. Law that actually was in GW2, and there I explored more the international arbitration area, which is with my first contact actually with ASIL, because there was a conference about it. And then that's how my interest became more and more towards this field.
Okay, great. Jeremy?
I would like to echo the thanks to the American Society and to Susan for hosting this evening. I got into international arbitration, at least my interest was sparked in a course when I was in law school. We didn't have a separate course on international arbitration, but a professor taught a class on international litigation and arbitration. I worked for another professor at the time who was giving lectures at the Hague Academy, and I went with him to The Hague when he was delivering the lectures, and I met the person who was clerking on the Iran-US Claims Tribunal. I had finished law school and I was going to do an LLM. I knew I wanted to concentrate in international arbitration and international law, and I was fortunate after law school, after the LLM program, to be able to go to The Hague and work for Judge Charles Brouwer, for whom this hall, I believe, is named after. And I spent 2 years working for him. I was very much interested in investor-state arbitration, and at that time, in the early 2000s, there weren't a huge number of opportunities in investor-state arbitration. But Judge Brouwer had opened the Washington, D.C. office of White & Case, and that put me in touch with his former partners there. I interviewed there and then went to White & Case for a few years to practice investor-state, some commercial arbitration work as well at White & Case. And then some 8 years ago or so, I went to the State Department, first to the Office of International Claims and Investment Disputes, which represents not only the United States government in these investment disputes, but also the interests of U.S. nationals abroad, espousing claims and so forth. I did that work for a while, did some other work in the State Department, and then about 3 years ago went back to the Office of International Claims and Investment Disputes to my current position.
So it's interesting that when you were in law school, it was a course that had a strong focus on litigation. I mean, it appears there was an element of arbitration in it. It was litigation that piqued your interest in the topic.
It was an interesting class. Andreas Lowenfeld Professor Silverman co-taught a class that was international litigation and arbitration. And what they would do is they would take some aspect of arbitration that was wending its way through courts somewhere. So the first half of the class was a lecture class where we learned the basics of international litigation and arbitration. And the second half was kind of a practical class where you played the role of advocate and arbitrator or judge dealing with some aspect of international arbitration. So it was something of a unique class that the two put together. But as I said, there wasn't a distinct class in international arbitration, which now I think there most certainly is, and probably investor-state arbitration and so many other options that just didn't exist 15, 20 years ago.
Can I just follow up on one other point you made, and that is in the early 2000 period, you started focusing on investor-state arbitration, but there weren't that many cases. Are you surprised at where we are today with the level of activity in that field, and do you see this as a growing area for budding lawyers?
Absolutely. I was thinking as you were making your introductory remarks about statistics and job opportunities, something that Judge Schwebel has said that the turn of the last century, the 19th century to the 20th century, there were probably 100 persons in the entire world that considered themselves and were considered by others as international lawyers. And now if you think about the field, from NGOs to government work to private law firms, in international law more generally and investment arbitration more particularly, it's quite astounding. So on the one hand, you could say, well, perhaps it's not so surprising that we have so many international investment disputes, given that there's this web of some 2,000, 3,000 investment treaties, bilateral, multilateral. So there are plenty of opportunities for disputes to arise. But this was there was such a dormant period where these treaties existed, but they weren't being used. So I think the fact that more and more people are aware of the existence of these treaties, there are more practitioners, they're better able to advise their clients on the utility of investment arbitration. So I think probably everyone in the field is quite surprised, not that the opportunity wasn't there for a large number of investment cases, but just the explosion that we've seen over the last 10, 15 years.
Yeah, it's interesting in that when you think about opportunities for recent law graduates, this conversation would not have happened 40 or 50 years ago because of almost the fact there were few people working in the area, but it was also highly concentrated, and it just wasn't seen as growth. It was seen as being controlled by states, largely by states, and unless you were a lawyer for a state on the treaties issues, at least, there wasn't much room. And then on the commercial side, it was also, I think, fairly closed. And then there were these elite lawyers that handled the cases, and maybe one day in your life, after many years of service, you would rise to be called to handle such a case. Victoria, any words you want to share with us about how you got to where you are and now teaching in the area of international arbitration?
Yes, thank you so much, Susan, again, for inviting me here, and to Georgia and also to Liesl. This has been a wonderful event, and I'm so excited that you're having this because so many people have asked me this question: how do I get into international arbitration? So it's great that you're having this event and that you're webcasting it as well. So my path was a little circuitous, I would say. When I was an undergrad, actually, I was interested in international dispute resolution, sort of in the idealistic, theoretical sense. I want to, make world peace and that sort of thing. And I thought, okay, to get some credibility, I need to go to law school. No one's going to let me broker their world peace with just a bachelor's degree, right? So that's what that was my premise for going to law school. And I took every possible alternative dispute resolution course that you could take. But I didn't take international arbitration, and I believe that it wasn't even offered at my school at the time. I'm not quite sure, but I believe it wasn't offered. So I took negotiation, mediation, that sort of thing. So that was sort of my focus. After law school, I joined a law firm, and that law firm put me in their transactional group. So that's where I was. So I was not doing dispute resolution, but I gained a lot of great experience in that group. I was working on tax credit financing and municipal bond financing for real estate transactions. So it was actually really helpful experience. At the same time, in the back of my mind, I always thought, well, I still want to do dispute resolution, especially international. That's what I want to do. So I sort of kept my ear to the ground. I kept looking, and when I had some free time, I would look on the internet or whatever and see if there are opportunities out there. And that's how I actually saw the opportunity with the ICC. So the first piece of advice I would give you is always keep looking, because when a window of opportunity opens, it's going to be very small. So you need to be the one who sees it so that you can apply. So that would be the first lesson, I would say, from my experience. So the second thing is, when I applied, I started looking through my background to figure out who did I know that could possibly be connected to this industry. And it turned out, my one-off summer, I summered at a firm called Holy Holette, which actually has an office here in D.C. I was in their Boston office. And I worked with a partner there on an investor, on a state-to-state dispute. It was a boundary dispute. And she was wonderful, and she and I kept in touch, and she was willing to be a reference for me. And it turned out that she was on the ICC Commission on Arbitration. She knew the person who became my boss. And so she was able to, help me in that respect. So when her name was on my list of references, my boss at the ICC pulled me out of the staff. So the second piece of advice I give you is keep your contacts. You never know who might have a connection into whatever it is you might be interested in and might afford an avenue. So that helped me out a lot. And so then I was at the ICC. I was at the ICC for almost 5 years. I was deputy director of their New York office. I'm doing arbitration and ADR work there. And my boss actually became involved at Fordham as an adjunct professor teaching investor state arbitration. She had me help her, and I became an adjunct as well, teaching with her. And that experience sort of exposed me to teaching. So if you're interested in teaching international arbitration, the adjunct work is a possibility as well. So that's something to think about. And so that's sort of how I got the teaching bug. And then publishing. I was publishing, wrote a book while I was there at ICC on third-party funding and international arbitration with my co-author, Lisa Bench-Newveld. And it was a great experience, a lot of work, but that really teed me up, sort of the combination of the adjunct and the book. And fortunately for me, I had a very supportive boss. She was one of my references, and she was willing to go to bat for me when I was out there looking for a teaching job. And so, that's another reason I say, make contact, keep those contacts, because you never know who might be able to sort of give you that push in that direction.
Victoria, when you joined the firm, not the summer firm, but you joined the firm, you weren't working in arbitration at all, but on your own, you started doing your own digging. Was there any opportunity in the firm where you worked to do any international arbitration? And I ask because sometimes one of the ways you can open a door is just by letting people know you have an interest in this. Because if you're in an institution, many times they may not know what your real interests are, and something can come in down the hall, and if it's an area where you really want to work, you want that person to say, we need to call Victoria on this. Was there any opportunity at the firm when you first started out?
There were opportunities at my firm. I worked at Pillsbury, and so Pillsbury has international arbitration, but I was in their San Francisco office, and that was not where the international arbitration team was based, and so it was tougher for me. Plus, at the time, the group that I was in had a lot of work, so it was. I think it would have been tougher for me to do that from the location where I was. But I think there's some other firms out there. And Pillsbury is one of them. If you're in an office where they're doing international arbitration, I think that you can have that opportunity. But I think that at many firms, they will allow sort of cross-office use of associates. So if you know that there's a partner in some other office, if maybe not in your own office, if they're down the hall, great, go talk to them, tell them you're interested. Every chance you get, tell them that you're available to help them work on a matter. That's how you can sort of get in with them, and maybe they might pull you in on a case. But if they're not down the hall, you can maybe pick up the phone and say, hey, I'm in a different office, but I'm really interested in your work. Please let me know if there's any way that I can help you. I think you can still make that connection.
Great. Juan Felipe, you have, like Daniela, you come to the United States from another country, and this country is Colombia, and he actually had degrees in France and in his own country, and to do graduate degrees here in the United States. How did you end up, after your education, getting involved in international arbitration?
Thank you, Susan. And first of all, I have to thank ASIL, the organizers, for having me here. That's a really difficult question, and the reason is because I have to make a confession. I got here by accident. It was totally unexpected, and I was not looking for it. One day, I was in my home university in Bogota on the top of the Andes, and I was very young, it was 10 years ago, and I was walking and I saw a poster that said, apply for an internship at the ICC, at the International Chamber of Commerce. If you speak French or English and you have good grades, you should apply. And I said, this. I didn't read arbitration. I didn't know what that was. But I was like, I've never been to Paris, and I have to go. So I applied for the internship to go to Paris to do arbitration. And I was very lucky. The reason is because the then Deputy Secretary General of the ICC was a former student of my university, and that's why he offered the internship to my university. And when I got there, I didn't know anything about arbitration. But I was in Paris, and I was very happy. And before, when I was in Colombia, I did some clerkships for judges and attorneys, and I saw some litigation before courts. And suddenly, when I saw what arbitration was, I fell in love with the concept. I was already in love with Paris, but arbitration was even better than Paris. Because all the formalities, all the procedure of litigation, they were gone. These guys, they were regular people taking care of regular disputes, but putting emphasis in the substantive issues of the case. Procedure was secondary. So I thought that this is totally groundbreaking for a Colombian guy. These guys, they just swim across the facts just to find the right decision without taking care of all the procedure in court litigation. And I thought that that idea was brilliant. If you add also the fact that it's international, and that I loved the idea of something international. So that's at the end of my internship, I decided I have to come back. I have to do something to stay in this field. So I applied to a university in Paris. I was admitted. I ended up graduating in Paris. And I stayed in touch with the people at the ICC that I worked with, and actually my current boss, she was the Secretary General back then. And I always did what you were saying. I was always telling them, I'm interested in this. I'm very young. I still have to graduate. I still have to do a master's. But when I come back, I want to continue working at this. And I did. I graduated eventually. And I applied for a job at Decker in Paris. And I was admitted. And I've been there ever since. I was transferred to the US in 2010. I did an LLM. And I knew that I wanted to stay in this international field and that arbitration was the best way to do it. And if I have to tell you something of how to encourage or how to develop a skill so that you may be someone interesting for international arbitration, is to become somehow international. When I was in Colombia, I say I have to go to France because I have to be something more than just a regular Colombian. And when I saw that small window of opportunity, I put my finger and I kept trying opening so that I could become something more than just a regular attorney with an international background.
Well, a poster takes you to Paris. Lovely story. Juan Felipe, when you were in Paris at the university, did you, in your degree, take courses in international arbitration?
Actually, I did not. I took courses in private law because someone, and here I hope I don't go into another question, but someone once told me a very good advice. He said, if you want to become a really good attorney in international arbitration, you have to be a good attorney, and you have to know the law. And for me, it was very interesting to learn private law from the people that educated South America in private law, who were the French. They wrote civil law, and I was there where civil law was written 2 or 3 centuries before. So I said, I'm just going to learn all these courses in private law. I only took international arbitration courses in 2010 when I went to NYU after I took actually the same course that you were talking about after 2 years of practicing international arbitration.
And they have a course. Does NYU now have a course on international arbitration, or is it still just international litigation and arbitration?
Now they have like 10. 2 years ago when I took the MLM, they had 5. It's multiplying in an unproportional dimension. Now they have a lot of courses in both, either a course in commercial, another one in investment. You have one in substantive issues of investment, another one in procedural issues.
And I've seen some that with a focus on Latin America, another focus on China. I see we have a number of students here from those regions of the world. And And I do wonder the value of having all these different courses. Getting back to your fundamental observation one, Felipe, and I think that it was picked up on by the other commentators, that you do have to have some sense of grounding in being a lawyer, what it means to be a lawyer. And Charles Brower always says that when he started his practice, he learned how to be a U.S. litigator. He went to the courts, and you are in the courts, you're rolling up your sleeves, and you're learning how to present evidence, you're learning how to make arguments, you're learning about your system, and it's those skills that then translate into an effective arbitration practice. Because we heard from Victoria, you didn't take a course in international arbitration.
No, I did not take a course in international arbitration. I didn't practice in international arbitration at the firm either. But one thing to note about international arbitration, which is actually part of my job at the ICC, most people who get involved in it as parties have never been involved in or taken a course in international arbitration either. They're new to it. And so part of what we do at institutions is educate them. So if someone who hasn't taken a course can learn about it and do it successfully and use it to resolve a dispute, then so can you. So I don't think it's necessary. I think it's helpful. I think it's interesting. But I don't think it's necessary to take a course in international arbitration to be successful as a practitioner in this field.
Jeremy, what are your thoughts on that? Given your experience at NYU and then your experience in the field since then.
I agree that it would be useful if it's offered to take a course in international arbitration, and ultimately I did during my LM program. But I'm not sure that employers would necessarily be looking to see if you had taken a course in international arbitration, precisely because they don't have this preconceived idea that you'll have some expertise in the substantive law as a junior lawyer. Rather, they're looking for an excellent lawyer, as Susan suggested, somebody who can do the work of a young lawyer in putting a case together, somebody who has strong analytical skills, writing skills, and you can develop oral advocacy and so forth as you practice. Nevertheless, I think a lot of people do go into arbitration work precisely because they have taken a course and it's sparked an interest in arbitration. So if it's offered, I think it's worthwhile in taking. And it is truly extraordinary the number of courses that one can take. I suppose you have to be judicious about the courses that you take, such that you don't specialize as a law student and miss out on taking the core courses that one should take to be a well-rounded lawyer and put yourself in the best position possible to be effective, whether in a law firm or an institution or elsewhere.
Daniela, did you take international arbitration in Costa Rica, or of course, I know we offer one course in international arbitration too.
No, international arbitration, the course I took it at GW, no, back home there was only like the ADR general course and focused more like on general practice in arbitration at a local level, not international level.
Let me ask a question for Victoria and also for Daniela, and perhaps Juan Felipe could chime in too, because he did spend time at the International Chamber of Commerce. And that is Daniela, you are spending your time not as an advocate, you are managing a process. You are dealing with lawyers, you're dealing with the arbitrators, you have, I would imagine, mastered the system of rules that are part of the ICSID framework. Do you think that that is a good way to start in this field?
Well, so my experience at ICSID has been a little bit of a combination, because I first started what we call like half between the case teams and half also between the institutional part, which is currently what I do. And the institutional part is mostly the part that it deals normally with the member states, the panels, and then when I was working with the cases, that's when we dealt and I assisted dealing with this, what you call the managing process. I think it's really interesting to learn the way and how to guide, because ICSID, what it does, it administers the case. I mean, it doesn't decide. Arbitrators are the ones who do that. But it's very interesting how secretaries of the tribunal and ICSID guide the parties in order for them to have, to get to a result in the case that is efficient, cost-effective, and also helps them to get to a solution, that will benefit both parties.
Well, that's interesting, the two different capacities that you had at ICSID, one dealing more on the secretariat side, and then the other dealing with the bank institutional aspect of it. And if I could just follow up on this before, which is there one that you prefer over the other, or?
I think they're really interesting. Both of them have complemented me within my work at ASIL. One makes you deal more with the state itself, the relationship with the state. You have to have the diplomatic level, the way you address them, more towards the panels, what is the membership. So it's more about the institution itself, the relationship about the institution with other institutions, with the relationship with their governments. So that part is very interesting. You learn about how to intercultural, you learn how to adapt differently in different environments of work, which I think is really good. And then the case part also gives you to learn all the procedural aspects of the convention in general. And I think both of them have, I have benefited a lot from them. I have learned a lot in ICSID from being in both parts, both different parts in the institutional side and in the case teams. And I think, well, if somebody has a chance to do it, I would guess working in both aspects, it really complements you as a lawyer because it gives you different perspectives of within the same institution and within the relationship that the institution has, towards the public.
Great. Victoria, your route of starting out at the ICC, is that something you would recommend, or do you think that new lawyers should be rolling up their sleeves and trying the arbitrations?
I think that you should get in where you fit in. I think if you can get it, the experience at a firm, go for it. If you get your foot in the door in an institution, go for that. This is very much a networking field. So I think wherever you get in, you'll start to meet people that can help you get your next opportunity. So I don't know that you want to necessarily try to carve your path in a very defined way when you're just coming out. I think you want to make your interest known broadly, as Juan Felipe said, and make sure that you're constantly reiterating to people that you know that you're interested in this, so that if an opportunity comes along, they will remember, oh yes, that person told me that they were interested. Let me contact them and see if they want to get involved here. So that's my advice.
And Juan Felipe, any thoughts on how you started? It was the poster to Paris that got you the internship with the ICC, but would you recommend that be the best way forward? Or?
Thanks, Susan. And I don't think there is an ideal starting point. I think that either point, wherever you start in the board, you're going to find a good way, the good path. Daniela was mentioning something very, very accurate, which is it's great if during your early career or if during your career you can try the different actors of international arbitration. If you understand, no one will understand better how the institution works as someone that was part of the institution. So if at some point you're part of the institution, then when you become counsel, you're going to know how the institution works, and it's going to be so much better. And also, if you can, and this is something addressed to young attorneys, try to ask your partners that act as arbitrators to allow you to participate as administrative secretary of the trade house. That is something where you will learn a lot. Because if you understand how tribunals and how arbitrators think, what's in their mind, you're going to be a better counsel. So if you manage to rotate, I know that it's not ideal, it's not even easy, it's very difficult to rotate in this field. That would assure you a great career.
You talked about that important relationship you established at the ICC and how it's carried forward in your life and professionally in particular. How key is it that you know the insides of the ICC and you know various management-related, administrative-related issues, and is that something that enhanced your marketability?
I think it does. I think that, for instance, a few weeks ago we were pitching for a client that is considering initiating an ICC case, and he was considering 2 or 3 firms. And we emphasized on the fact that we knew how the ICC worked from the inside, and that we still knew many people inside the institution, and that was a very important point for us. And we got the case, and probably the fact that we could sell ourselves as someone who were in the institution and who knew the institution better than any other practitioner, that was an important point.
I think it's important that anytime you have an affiliation, and this is one of the lessons I think we've picked up already, but anytime you have an affiliation, whether it be a summer associate position, whether it be in a class, whether it be interning in some institution, you're developing relationships. Of course, you're working on substantive issues that could be of interest, and you can write and get your name out, but it's the relationships that you need to impress people and be able to then build on those relationships as you go forward. I'd like to, if we could, just be a little more focused now on how a current student or perhaps a recent graduate, what is the one skill that you think that they should be encouraged to develop and focus on? Jeremy, any thoughts on that?
I think that you can't overemphasize the need to be a good writer. Almost all the work that I do on a day-to-day basis is writing, whether it's writing emails to colleagues, letters to tribunals, letter submissions, briefs. We write scripts before we present before international tribunals. And there are a lot more opportunities for you to practice writing and publishing. I think law blogs are a great opportunity to publish. Student notes can be a great opportunity to publish. On the student notes, if I could just make a pitch for, if you want to write about something in arbitration, there are lots of interesting areas that simply haven't been covered or covered very well. And you can make a very important contribution to the field very early in your career by trying to identify something that hasn't been written about, rather than the kind of piece that somebody has been practicing for 20 or 30 years. I'll give you an example. We just had a request from an appellate court for the United States government to weigh in on an issue. And at first, it was tricky to get your mind wrapped around this issue. And I found a student note on this very topic that seemed relatively obscure. And he had looked at the cases, he'd analyzed the cases, and had made a proposal at the end. But it was an excellent resource. And I think this is something that the student will serve him as a lawyer and being able to show, especially if this appellate court then cites this student note that's been written, which is essentially, as far as I could tell, the only substantive piece that has been written on this. But also, don't overlook blog posts, which are increasingly important in an area like international arbitration, where there are so many cutting-edge issues, very topical issues that are being discussed. So a lot of practitioners don't have the time to write a lot of pieces, and if you have the time as a student or a young lawyer to write something, get your name out there and publish it, it's both terrific for polishing your writing skills, but also showing employers and prospective employers that you can write at a professional level. I think that will greatly advance your career.
I think it's interesting that you can now get access to a lot of information about arbitration, and we have courts in the United States, for example, that are very engaged on the subject matter. 30 or 40 years ago, in the international context, there wasn't a lot. And so, if you are in the books, reading what's going on, following the news, I mean, my goodness, we have had a number of international cases before the U.S. Supreme Court now involving Argentina. It is just a lot of opportunities for students to focus on specific issues and take discrete issues and start writing about them. Danielle, what would you recommend?
I think, well, I would recommend, yes, of course, drafting skills, like Jeremy said, and following that point, I think also, besides the student notes, the student writing competitions are also very important. For example, ASIL has one, and other institutions have one. That's a great opportunity for you to get your name published. Also, well, the different reviews that are out there. For example, I can talk from my experience, which is the ASIL review. But there are other reviews also that you can, publish your notes, get your name known. Because actually, while I was doing my LLM, one of my professors told me that a really good way, and a really good advice, a really good way to know, that people can start knowing your name in the field, is by writing, and start writing and getting your name out there, like Jeremy says, like in different topics. Also, I think, like, besides the drafting skills, I believe also teamwork plays a very important role, and especially in this international area, because you're working in teams. I mean, everything is just so complex that it's not only one person dealing with it. So I think working in teamwork and trying to get that ability, I mean, there's some people that are good at working by themselves, but if you try to get and explore that ability, I think it's really important, along with communication. So that would be my advice in this area.
But it is very interesting, because many of the cases, particularly in the investor state area, you're talking about substantial teams and perhaps a reporting hierarchy, and then perhaps even outside of the State Department, folks that you may be working with and the like, and developing the skills to listen, to communicate, to be able to manage relations. I think those skills are very, very important, and you start learning those skills when you're young, and you have to constantly stay focused on them. Juan Felipe, what one skill would you think, if you had to identify just one that is critical to your professional development in international arbitration?
I think Daniela and Jeremy mentioned most of them. I would add organization. You have to be very well organized, not only in terms of time management, but how to organize your work. In this case, you were mentioning the size of the teams, so you can imagine the size of the files, the size of thousands of documents that you will be revising. So if you have good organization ways to file your documents, or to I don't know, make a summary of every document that you've read on a table. Those kind of skills are also very welcome in first-year associates and summer associates.
Victoria?
Yeah, I actually would sort of add myself to the chorus of writing is the most important thing. But if I would say there's something that is sort of secondary, it would be oral advocacy. International arbitration is one of the few areas where, unlike civil litigation, you go to trial a lot more often. Many civil litigations settle, so there's not a lot of time standing up as much, arguing motions and cross-examining witnesses as there used to be. And so international arbitration is one of those areas in which, yes, cases settle, but a lot more cases go all the way through. And because the teams are smaller, you may actually have an opportunity, possibly, as you sort of advance a little bit in your career, to argue sort of a motion or question a witness, where you wouldn't necessarily get that if you are, the 30th associate on the giant commercial litigation case. So while you're in law school, you can get involved in moot competitions, right, to hone your oral advocacy skills. In particular, there's one on international commercial arbitration. It's called the Willem C. Viz. International Commercial Arbitration Moot. If your school is not involved, you should ask your dean if you can get involved in that competition. It's a great way to meet people, for team building, as Daniela mentioned, for writing, as Jonathan mentioned, and as well as organization. I mean, it's a case, it's a real case that you have to argue. So it's a great competition, as well as other moot competitions as well. So I would say work on your oral advocacy skills.
Yeah, I think it's fascinating that, again, going back to when I was in law school, we didn't have international arbitration as a course. We didn't really have a lot of international arbitrations going on that students were aware of, and therefore there were not journals focused on it, or places to put papers on the subject. Also, there weren't these competitions, and I think there's a competition a week going on around the world, whether it be in specific arbitration or other kind of advocacy. And if you want to participate, there are plenty of opportunities, and I would encourage you to do so. I think that one skill that I'm surprised nobody said, and I think, Danielle, in particular, it would be critical for you, and Juan Felipe, it was critical for you, is language skill, the language skill. That I would imagine you were, at least for ICSID, given the case volume that involves Spanish, it was pretty important that in that hire your Spanish was essential, right?
Yes, I believe that, well, in this area in particular, I believe that having at least a second language is very important. And if you have a third and fourth, I mean, of course it's a plus, but since you're dealing with international organizations, international clients, we're dealing with states, we're dealing with different parties from different parts of the world, I think like Spanish, French, I mean, and other languages are, I mean, if you can, I would encourage you, if you don't have a second language, to enroll in one and learn one, because I believe it's really important.
Yeah. Well, did you want to say a little bit about that? Since you came from Spain to Paris, and now you're here?
I agree with you, and some may say that learning language is easy, and maybe it is, maybe it isn't, but learning legal proficiency in another language, that is the key issue. If you think that you speak French because you took French courses when you were at college, or because you had a French father and you grew up in the States, it's totally different than to understand the legal vocabulary in French. Because you cannot translate, like an interpreter, immediately the literal meaning of a word from English into French and make it sound legal. It's absolutely different. So if you're interested in taking that second language that you already have and making it a legal second language, I'm sorry, start reading words in that language, start reading legal books in that language, take an exchange course, take an internship at a law firm in a different country. Big law firms, they currently have a lot of offices, and they encourage taking secondments in another office. Go to that office if you can, because that will give you a huge plus in these kind of cases.
Are you working in Spanish a lot out of the office here in Washington?
I'm working 70% in Spanish, 30 English, and absolutely surprisingly 0 French.
Great. Well, this is intended to be a discussion, and we have a room full of individuals who I imagine some want to participate as a lawyer in international arbitration, maybe on the commercial side, maybe investor state. Others may be looking at working at one of the secretariats or one of the institutions. And so we would like to hear from you. Any questions or comments that you may have about the topic? We open it up to the floor. Here's our first question. Yeah, just a second. We'll get the microphone to you. Just a second. And if you could introduce yourself, please.
Hi everyone, my name is Desha. I was lucky enough to have the experience at the ACC as well. I just got back actually from Paris. It was very hard to come back this weather. It was amazing, as I'm sure you guys had the same experience. While there, I had a lot of conversations about the LLM and just how important it is. Lots of the councils there say, you know, if English is not your native language, then absolutely. And if English is your native language, not necessarily if you have a JD. And this is something I think is very inconsistent, and I'd like to know what your thoughts are, especially as a professor, and having done LLMs. Thanks.
Go ahead. Okay, go ahead. Well, thank you very much for your question, Desha. Here's the thing. If you want to practice in the United States, you're going to have to be either licensed in the United States, or if you want to do international arbitration, you need to be doing an international arbitration in a state that allows foreign attorneys to do international arbitrations. There are some states, California is one of them, that has laws that say you must be licensed or registered with the bar to be able to even do an international arbitration within that state. So this is where the LLM question comes in. The other difficulty is that there are certain states that will allow the LLM with certain stipulations to take the bar, and other states that say no, you have to have a JD. So the difficult thing in the U.S. is we don't have a national bar. We have this sort of state-by-state system. And so you'd have to sort of look at each state, and depending on whatever state you want to go to, see what the rules were. But traditionally, people come to the U.S. And get the LLM to practice in New York, Washington, D.C., right? And so those jurisdictions do allow people with LLMs to take the bar. So that's sort of the difficulty if you want to practice in the U.S. Now, if you don't want to practice in the U.S., the LLM, it would depend on the jurisdiction where you want to practice to what they would require. But the key is you need to be licensed. Even though international arbitration is not necessarily directly tied to the local courts, you need to be a licensed attorney It's helpful if you're a licensed attorney in a jurisdiction where the arbitration is seated, or you can partner with local counsel. I mean, that's another option as well. But if you want to practice in the U.S., you have to do whatever is required to be eligible to sit for the bar.
We have, and on the panel, we have two speakers who actually pursued the LLM route. They may want to chime in on the question that was asked.
Oh, well, thank you for your question. First, well, I believe coming from Costa Rica, which is a civil law country, I think it's different because since we have to do our general law degree, for us, our LLM is more like our specialization. So we're looking towards like focusing on one area, which is the one that is of your interest. In my case, it was arbitration and international law, which is what I decided. But I guess it depends what you want, because also for international organizations, the bar itself is not a requirement. It's preferred though, but it's not a requirement because you're dealing with people from all over the world. I mean, so. But if you do want to practice here in a law firm, or in a law firm here in the United States or any other country, I think, yeah, I would advise also to having to get the bar and classes that would allow you to take the bar now that all the rules have changed, at least for New York.
Sorry, if I could just alter my question. I'm asking from the perspective of having a JD and not a foreign law degree.
Oh.
So how
okay.
necessary is an LLM for arbitration, given that?
Not necessary.
Oh, okay.
That was it. Sorry, different answer. I apologize. I didn't understand.
Yeah, I understood it.
Yeah,
My question was, at the ICC, they were saying if you're not an native English speaker, then an LLM is absolutely necessary.
Well, that's because of the bar. That's why they were
Correct.
advising you that. Yeah.
So, but then people say if you have a JD, it doesn't matter.
Right.
So
That's correct.
that was my question.
Yeah.
And if I may add on, that I've seen the hiring process in different law firms. I have never seen that elements are a requirement either for JD students and even for international students. So you have to be admitted somewhere. You have to have some legal education.
But it's interesting in that in preparing for this session, one of my former students wrote to me from Paris because he saw that the panel was going forward, and he just wanted me to convey that in the area of international arbitration in Europe, that there are a lot of professional opportunities. If you have the language skills, that the firms are looking for very able people to work in this field. That is it's a booming area. So questions? Yeah, we have a question. Oh, go ahead.
I just wanted to add something to that point, which is if you are an American student in the US and you want to find a job, you're going to be competing against thousands and hundreds of thousands of students. But if you go to Europe, you're going to be the student who has the best English. So if you change the ecosystem where you are, you may become the best at something. And I think that one of the reasons why people are hired is because they are the best at something.
I think that's very interesting, and I got the impression that was part of the message I was hearing from my former student in Paris, was the demand for English-speaking lawyers from the United States. Mind you, they do want proficiency in another language too, Spanish or French or Chinese or Arabic. But there are opportunities there that sitting here today you may not be focused on. So.
Hello there. I'm somewhat new to the notion of arbitration, and I'm a lawyer in DC. I work for the federal government, so I've been practicing for a number of years. But my area is administrative law, so I didn't summer at a firm. I don't really have significant litigation or transactional experience. And I was just wondering, in my circumstances, are there opportunities to sort of get your feet wet while still continuing with the existing profession without fully wading into the pool? So are there sort of volunteer opportunities to do arbitration that
Jeremy, do you want to chime in on that, since you're also a government lawyer, and there may be certain restrictions that are unique to the State Department or something? I'm just not sure. But
I'm not sure I can answer the question directly, but perhaps expanding it a bit, just by noting that, as Susan intimated earlier, the arbitration aspect, or the investment arbitration aspect of the U.S. government, although directly handled by the U.S. State Department, has broader implications for the U.S. government, and therefore involves many other agencies. And so we have, for instance, the Office of the United States Trade Representative, which co-negotiates the bilateral investment treaties and negotiates has the lead on the free trade agreements with investment chapters, the Treasury Department, the Commerce Department, and so forth. So there are lots of agencies within the U.S. government that deal with arbitration. Now, whether one can be a U.S. government official and do sort of pro bono work on the outside, I'm not sure. I do know that there are some NGOs that do provide pro bono service to states or to others that are involved in international law. I'm not sure if it is done in international arbitration. I did have occasion to participate in a clinic when I was in law school, and it was essentially pro bono for East African states involved in interstate arbitration over some islands in the Red Sea. And so I suppose there must be some opportunities out there for this kind of pro bono work. In this case, it was done through a professor, but perhaps in other circumstances it might be done through a wider group of individuals.
Very, very interesting, because the question, when I first heard it, I was saying, boy, I imagine it's fairly limited, but I think Jeremy gave us a fairly expansive answer. If I could just chime in on this, and then one thing, I don't know if you wanted to add something. I saw your hand perhaps go up, but one thing is to do exactly what you're doing now, is to learn about it and to get engaged in institutions that are focused on the issues. And the American Society of International Law is one of them. There's the Institute for Transnational Arbitration. There are all the centers that we have talked about. And then learning the subject matter, and as Jeremy had mentioned earlier, writing in the area. That is not a way that you're going to have first-hand experience rolling up your sleeves and the like and observing, but it is a way that you're going to learn the subject matter. It can be very complex, because in the commercial context we have a system that is a private system designed to keep you out of court, but a lot of times the courts are involved. And interesting relationship between the dispute resolution system the parties want, and then the role of state courts, whether it be local state courts or federal courts here in the United States. Montgomery, did you want to add in anything with this? Victoria?
And just sort of building on what Jeremy said with respect to the pro bono work, there's actually part of the ABA in their international law section. They have a listserv where they send out these pro bono opportunities to work on various issues, and I've seen a couple of times a dispute resolution or arbitration issue has sort of come down the pipeline. So that might be a possibility to sort of join that listserv and see if there's some pro bono opportunities that way. Another thing to consider is that all of the major international arbitration institutions have young arbitral groups. There are various names, but they're typically free to join. And it's a great way to get to know people in the field. So it's not necessarily doing work per se, but you can get your feet wet, maybe getting involved organizing a program or some other a way of getting involved, at least programmatically or educationally in the field. And then from there, more opportunities may develop. So those are two things that I would suggest.
Perhaps while we're on the subject, if you haven't already looked up this tremendous resource that Mark Cantor has put together with the Georgetown International Arbitration Society, I encourage you to look at it. You can Google it. It's called How to Break into Arbitration, Useful Resources for Students and Young Practitioners. And as Victoria was mentioning, there are lots of young associations of younger practitioners, ICC and ICSID and LCIA and so forth. Huge number of listings for newsletters, publications, events, law firms, and so forth. So it's a terrific resource. So if you haven't already taken a look at that, I encourage you to do so.
Thanks. Any other questions in the audience? Yes, sir.
My name is Brian. I was wondering, how often do the disputants choose to have the law that's applied in the arbitration to be from a civil law-based country? And if they have, if one of them is a common law-based country and the other is civil law, how helpful is it to understand the civil law of the other country? I guess this would be best for Daniela and Juan Felipe.
Probably Juan Felipe in the context of commercial arbitration.
So in the context of commercial arbitration, Brian, I think the answer depends on the contract, right? If you have a contract that's going to be executed and that's going to be performed in a certain country, and that such contract is going to have an impact in that country, it's probably advisable to choose the law of that country. In another ground, we were mentioning the fact that you have two different countries and two different parties. They may decide to choose either the law of one of them or a neutral law. To answer your question, I think it's fundamental to know that law. Not only when the dispute arises, but when you sign the contract, when you enter into the contract. And that is one of the advantages of international arbitration, is that you have a huge network in different countries, and that when you need a local lawyer specialized under one law, you can probably either someone or someone who knows someone, and that also opens the way for you to sell yourself I've been contacted because I'm a Colombian attorney, and they say we have a contract under Colombian law, so you may have to help. I think that would be it.
Anybody else on the panel want to comment on it? Because I know, Danielle, you may deal with investor state, and you don't get into some of those more private related issues. It can come up, I guess, when you have a contract dispute and the state is a party to the contract, and you may have these local claims that are arising, whether they're covered by the treaty or not. But
yeah, I guess to follow up on Juan Felipe said, it's always a plus to know, I guess, the civil law system, and at least of how it works, that you can compare and contrast and understand, what you're trying to, in order to draft and what you're trying to defend your client. I guess it would be always a plus to understand both systems and have the knowledge, if you can, in one of them, that it's not only one system versus the other one.
thank you. I thought there was another question. Was there over here? Let me follow up then on this question and get a sense that maybe Juan Felipe can launch an answer to this, and then those who are advocating can answer it. But is the system of arbitration, has it become more like an American litigation proceeding? And that is, do you need the cross-examination skills that we here in the United States develop if we're going to manage it or represent a client in court? And would you be served by taking advocacy courses if it has become that?
So my answer would be yes, with a caveat. I think that indeed the common law practice of conducting a hearing has made a huge way into arbitration. We have, not only in cross-examination, but also in presenting arguments, opening statements, closing statements, we have seen how common law has emerged into international arbitration, even in disputes involving two civil law parties and under civil law. But the caveat, I think it would be fantastic for you to get training in moral advocacy and techniques of cross-examination in U.S. law. However, I have seen in international arbitrations, North American Council that conduct cross-examination like they would in a U.S. court. And they get really beat up by the arbitrators because it's very different. I think that probably in the U.S., and maybe Jeremy can enlighten me on this, they tend to be more aggressive with the witness and the
Americans? Aggressive?
Did you not say aggressive? And in commercial arbitration, they tend to be, there are different rules. Not less aggressive, but for instance, in the US, they tend to attack a lot the credibility, and they tend to go beyond the scope of the witness statement and the expert report. While in arbitration, you have different rules that have been. If you look at the main set of procedural rules in international arbitration, probably currently used is drafted by the IBA, International Bar Association. And if you look at the rules of taking evidence, you have different rules that are not the same than the rules of evidence in the US.
Jeremy, do you want to chime in on this subject?
I would agree that there's much less discussion today than perhaps 20 or 30 years ago about the civil law, common law divide in international arbitration. There are still some differences, but I don't think you would see the kind of observation that Jan Holtzmann made 20 years ago. You'd say the notion for a civil lawyer of having to turn over purely internal documents to an adversary in arbitration is inconceivable, partly because of the use of soft law, like the International Bar Association's rules on evidence, which have really tried to merge a civil law, common law approach, perhaps more to the common law in certain circumstances and more to the civil law in others. But it has helped perhaps parties on both sides, civil law lawyers and common law lawyers, understand the expectations. For instance, if you were a common law practitioner in an arbitration 30 years ago, a civil law practitioner, civil law company, you might be very loath to turn over documents for fear that the other side would turn over documents to you. And therefore, you might be trying to level the playing field unilaterally, which is not the ideal way to conduct an arbitration. So whatever the complaints about these various guidelines that have been issued, at least one advantage is it has helped manage expectations on both sides about what is the proper approach, what are the best practices for international arbitration. So I suspect, given that we have practitioners from all over the world attending many of the same conferences, participating in some of the same bar associations, we might see greater coherence in more areas. Now, there's constant criticisms that this results in ossification, there's less dynamism in international arbitration, perhaps taking some of the autonomy away from the parties. But of course, parties can always structure their arbitrations as they wish, but if they haven't answered these kinds of questions in advance in their contract, as they most often have not, then at least if they end up in an international arbitration involving companies from North America and Europe, say, then at least they'll be able to approach it with a much greater sense of what the other side might do during the arbitration than would have been the case 20 or 30 years ago.
Yeah, the interesting thing is there's been in the last 10 years a lively discussion in the literature about these issues, and the lawyers are talking about it too. And so they're very much aware of what this process is about and who the actors are and how they perhaps are changing the rules of engagement for better or for worse.
Oh. I'm Andres, and I've been doing some work about nature conservancy, and I'm really pointing that because some of the work that I've been doing is helping draft and structure agreements and contracts with governments or partners in different countries or multilateral organizations. And so I would like to ask, from people who are doing kind of more transactional and trying to think ahead, and when you're doing that type of work, you don't often think about what can go wrong or go into that instance of arbitration. So what are some advice on how to think ahead and what can parties that are probably haven't been in arbitration before do to prepare and to draft the agreements better, or what can you do to just prepare and think about those issues in advance.
Thanks, Andre. And I think the question's important because everything we've covered so far has focused on the arbitration itself and the skills you need to be an arbitrator. But as you all know, arbitration is based on consent, and you need to be thinking at the outset about the documents that are giving rise to the consent or the agreement and how that should be structured and the like. So perhaps one for you again, since you work in the commercial side more, maybe you want to take an approach to answering the question.
Sure, that's an important question, and I have to say that to answer very simply, there is a lot to do to be aware of what arbitration is and to take all the precautions necessary when you draft the contract. We have seen, and I know Victoria has seen at the ICC, the chaos that becomes understanding some parties' arbitration clause. And us as counsel, sometimes we receive a contract and we say, oh my God, what they did here. Not because of the substantive part of the contract, but the procedural part of the contract. And there are two clauses that sometimes are really difficult to negotiate, and sometimes the parties just leave that for the last minute, and that's why they call the arbitration clause the 11th hour clause. Because they just applicable law and the clause, the arbitration clause, sometimes they just leave it for the end, and they copy paste the clauses from another contract, and they don't realize that they are absolutely compatible. So, in my opinion, be very careful, because having a great contract with a bad arbitration clause is like having a great car without wheels. It's not gonna be used for anything. Once you have a dispute, you're gonna be, what do I do? Then you will have to spend a lot of money to correct the arbitration clause, either by going to the judges or trying to interpret the clause in a very big way. So be aware of that. Use model clauses. That's the good advice at the moment. If you don't know what you're doing, just follow the advice of someone who has already shown you how to do it. Because sometimes people tend to say, I'm an attorney and I can do it, and they draft an arbitration clause and they negotiate something. So that guy wants one arbitrator, my counsel wants 3, I'm going to suggest 2. No, those things don't work like that. So use model clauses, and be very aware that the arbitration clause is fundamental.
Right, but I think that on the model clause, you absolutely, as a lawyer, have to know the consequences of when you just take what the ICC has said. You have to know what the consequences are. You have fully studied it. And another important issue is on the choice of law, too. You have a full appreciation of the ramifications of the choice of law. Victoria, did you want to chime in on this subject?
But this is a question that we get a lot at the ICC in terms of parties drafting arbitration clauses or wanting advice on arbitration clauses. I mean, sometimes you'll get the 6-page arbitration clause that lists out all the steps and who can do X and Y and Z. And then when the parties actually have a dispute, they're saying, we don't want to do this process anymore. Why did we even put this in the agreement? So I think there's a tension between customization, which is why people like arbitration, and sort of boxing yourself in, because when you're negotiating the arbitration clause, you don't know which side of the dispute you're going to be on. So it's difficult to know what exactly you want the procedure to be. So I think model clauses are great. I do think that it is helpful if you add a couple of key parameters to your model clause. So you take the model clause and then you put in your seat of arbitration, your language of arbitration, your number of arbitrators. If you can agree on these things. If you can't, model clause is fine. But that'll save you a little time when you actually get to the dispute, but it's not necessary. And the thing about the model clauses, the reason why they're so important, the reason why they're written the way they are, is enforceability. The reason you're going to arbitration in the first place is because you want an enforceable result that your client can then take to all the New York Convention jurisdictions, right? And if there's a problematic arbitration clause, that's one of the first things that the losing party will attack when they're trying to attack the award. So that's the main reason why, if you really don't know what you're doing, the model clause at least will get you an enforceable arbitration.
Go ahead. If I may add just one last thing that Victoria mentioned, is the arbitration clause has to be a neutral clause. So every time that you negotiate a contract and you try to negotiate one clause by clause, you try to score points. You score a point with an additional representation or with an additional right or to qualify an obligation. The arbitration clause should be a clause that benefits both parties in equal way. Because if you try to score a point with the arbitration clause, you're going to be in danger of having an unenforceable award and having problems with the procedure afterwards.
I think that the discussion signals that if you, Andre, develop this expertise, you look at all the clauses, the potential clauses that are out there, think through the ramifications of it, that would be something that would be of value. That to your institution, and then you never know in terms of writing about it, expressing an understanding, working through how the clauses have been interpreted. again, adding value to the information that is out there to distinguish yourself, to get in the field. Did anybody want to add anything else about the clause? Let me just ask the audience, and how many of you want to work in the field of international arbitration? Okay, we have a good number. How many of you see yourselves as being an arbitrator at some point? Okay, I think there's a big difference between being an advocate, presenting a case, and then also being an arbitrator. I'd like to ask the panel, and how are we doing on time? Are we have, okay, yeah, but I want to make sure we have a chance to enjoy the reception as well. We always like receptions, and you never know in a reception where you can find that poster that's been taken care of. But the skills to be an arbitrator. When you think of the arbitrator, you think of somebody who has practiced law for many years and perhaps has arbitrated cases, presented cases, or you have somebody who has been a judge and now is off the bench and understands what it means to bring parties together to try to work through disputes. But is there any place in arbitration for arbitrators who are fairly young, energetic, know the rules, have written a little bit, have some experiences? Do you think we're going to see arbitrators selected from lawyers who are just licensed for 7 to 8 years?
I would say yes. When I was at the ICC, we were actually already starting to see that for two reasons. One is that the arbitrators who are, shall we say, more seasoned are often quite busy and too busy to actually get the case done within the timetable that the parties want because they've got too many other cases on their plate. Whereas the more, the newer, more junior person actually can devote more time and energy to that case and maybe get it done faster. And so parties actually may want someone who is not as, their time is more available. So that's one reason. The second reason is that parties may have specific stipulations with respect to the requirements that the arbitrator must meet. So for example, languages, and often at the ICC we get the request of find me a non-native X speaker, right? So like a person who's not from that country but who speaks the language. I mean, this was really difficult, but often the younger practitioners are the ones who would meet that qualification. So for example, a person who speaks Greek but who is not Greek, a person who speaks Japanese but who is not Japanese. This is the type of request we get, and many times it would be a younger person that would meet the requirement.
Yeah, and I think in the domain name disputes, where there are fairly newly licensed lawyers that have expertise in the subject matter, my understanding is some of them are acting as arbitrators, and it's not like they have been out in practice for 15 years or so. Any thoughts about this, Jeremy, in the context of investor-state arbitration? That is where the investor sues a foreign state under bilateral breach of promises, typically under a bilateral investment treaty, and that treaty authorized arbitration of the dispute.
I think the arbitrators are trending a bit younger, but I don't think it's quite the same as you might find in a commercial context because investor-state arbitration is very different. It's typically under treaties. It might involve very sensitive issues of sovereignty for the state, and the stakes may be incredibly high. So at least from the state's perspective, and even from the claimant's perspective, you might be looking for more of a known quantity. As Martin Hunter said, when I look for an arbitrator, I want someone with maximum disposition to my client, but minimum appearance of bias. And frankly, a lot of parties want to know what this prospective arbitrator thinks about some of the key issues, or is likely to think about some of the key issues that might arise in the arbitration. And the best way to apprise your client of that is to point to some awards, which this arbitrator has been involved, especially as a presiding arbitrator. And you're able to give your client some sense of how the issues might be approached by that arbitrator. Obviously with the caveat that one never knows how particular factual scenarios play out in a case. And the difficulty with the new entrant is it might be difficult to identify how that person has approached a similar issue that might arise, whether it's an MFN clause or a fair and equitable treatment clause. So there are younger arbitrators who are writing more and appearing at conferences, and that gives counsel a sense of the way that this arbitrator might approach some of these issues. So I think we will see more and more entrance into the field, but I don't think it will be quite the same as we're seeing in commercial arbitration, where we're seeing many more entrants and many younger. But nevertheless, I think with the number of cases that we have, the incredible busyness of some of the top arbitrators, that invariably there just have to be new people that are identified. One of the advantages of representing a state like the United States is it has its own counsel. And so although we go through the same analysis as another arbitrating party would go through and identifying an arbitrator that's appropriate for the United States in this case, it's not to pitch to the client, it's to discuss within the United States government, and so it gives us a bit more flexibility. So for instance, we've appointed a lot more women than I think any other state has appointed, simply because that's something that we've been interested in. And we've appointed people who have never been appointed to an investment arbitration case. Now we've looked at the background of that individual, and we think that he or she has the profile of somebody who could decide this case fairly, would understand be able to deal with the factual issues, understand the legal issues, be able to deal with the procedure, arbitral rules, and so forth. But nevertheless, someone who has not sat as an investor state arbitrator, someone who does not have awards that we could go read and see how he or she decided a question of MFN. But nevertheless, someone who has some confidence in as an arbitrator in this case. That's one of the benefits of representing oneself as opposed to having hired outside counsel. And so.
Well, it's interesting in that what we are seeing, though, and Daniela, you may want to pick up on this, is that newly minted lawyers are not able to serve as arbitrators in investor-state dispute, but they are starting to aid tribunals, serving as secretaries to the, or not necessarily secretary, but there are a couple of tribunals have now hired authorization. The parties have authorized the hiring of somebody to assist the tribunal, and these are graduates of law school, some of them having done LLMs or perhaps doctorate degrees, and I'm just curious if you have any thoughts of if that's a good stepping stone to entering into the profession.
I think, well, yes, actually, when I first contacted ICSID the first time, is because one of the positions that opened up exactly was because the tribunal was looking for an assistant. For an assistant of the tribunal, not with the secretary, because I wasn't working at the time. But even though I think it's a really good idea to start because you're working with arbitrators and these people have, they have a superior career and they have a lot of experience, you can learn a lot from them. You can also, also there are other possibilities, for example, being secretaries of tribunals, that would also give you a lot of experience working in different institutions, the ICC, ICSID, and LCIA and the others. Because you're entering yourself, you're knowing the process, you're getting to know what's going on. Still, you still don't have enough experience to be an arbitrator, but you're getting there because you're getting all the insights of what's going on around and insight within institutions and within, and also being in counsel too, of course.
Juan Felipe, did you want to chime in on this subject? In terms of the selection of arbitrators and any opportunity for a lawyer who perhaps has been licensed from 5 years to 10 years is getting selected?
I think that Jeremy covered pretty much everything, and I entirely agree with him that there are more chances in commercial arbitration than an investment arbitration, not only because of the size of the case and I'm going to say the public character of the investment arbitration, but also because you have way more commercial arbitration cases than investment arbitration. And as to Daniela's answer, I think that I entirely agree that a great way to enter and to become known as an arbitrator is as an administrative secretary. And I have I have a story about that. We have a very busy partner who acts as arbitrator in many cases, and he has different associates that help him in his cases as administrative secretary. And once I heard someone from the ICC telling me that he was expecting that someone from our firm would be the administrative secretary instead of that other person, because he knew that that person was going to deal with this case in a perfect way. And you become known to the institutions when you are an administrative secretary, and the day that the institution needs a young attorney to act as an arbitrator, the first pool of people that they're going to be looking at is going to be the administrative secretary.
Very interesting. Well, if I could just draw a couple of conclusions here to wrap up. I think what the sense that we have is that this is an area of the law that will continue to grow, that there are certain things that you can do now, whether it be polishing your writing, getting your publications out there, being very focused in your writing, thinking about emerging areas and tackling those issues, and also to be able to develop advocacy skills that can be important, and also knowing the relevant institutions, the players, and becoming affiliated with individuals, as you heard the phrase networking, but it is important to be able to meet the individuals that are involved in developing the field and gathering the substantive knowledge. You can gather that information a lot on your own, but you can do it in a formal course if you like. And advantages that each of you probably each of you has a specific advantage that you may not have thought about before you walked in this room, but I hope after you walk out of here and you've had the chance to contemplate what was said, that you will focus on it and think about how it can, the development of it could change your life. I think the other thing that I take away from this, and it's something I focus a lot now in whenever I'm talking to students, is we all wish that if we allocated our time and did X, that we would have Y results. But life is not like that, and that's the beauty of life, is that you should never see a decision you're making now as boxing you in, or is it a zero sum? I can only do this and not do that. You need to be aware of your environment and the opportunities that are there, and you never know when a relationship or a poster or anything can lead to something new in your life. And that is, we just simply have to be able to take some risks. And sometimes it's not really even a risk. Going to Paris is not a risk, but it can be life changing. And that's, you need to be aware of that when it's happening to you and carry it into professional life. So if we could thank the panel, yeah, go ahead. Yeah.
Could I just make a final point?
You bet, absolutely.
I meant to say, although I'm appearing in an individual capacity, not for the government, I did want to encourage you, whether you're American or foreigner, if you have the opportunity to do arbitration for the government, it's a wonderful experience. And there are many ways to get in. Even if you're in a government and you're seconded to a law firm that's representing you, or if you work for the ministry that's actually doing the arbitration for itself, for that state, or if you're working for another ministry and you can advise the ministry that's representing the state. It's a terrific opportunity for a younger lawyer, and I think you can get experience that you would never get in a law firm. For instance, we were involved in a state-to-state arbitration with a Latin American state a couple of years ago, and we had essentially a first-year associate in our office arguing in the Peace Palace against opposite one of the most experienced and distinguished international arbitration specialists and litigation specialists in the world. It was a phenomenal experience for her, but it never crossed anyone's mind in our office that she wouldn't be appropriate for this important position, because that's the way the government office can run its cases without having to respond to clients and so forth. So I didn't want to leave this distinguished group without making a plug for government work.
Yeah.
Thank you.
And actually, thank you so much, Jeremy, for reminding me about that, because we have in the audience here today lawyers and students from around the world. And when you are able to go back home, you can call your foreign ministry, you can call your trade department, or whatever agency or office that manages affairs on behalf of the government and handling arbitrations. And so you may be at a substantial advantage compared to the average American that to be able to represent the United States, as just described, that's an uphill climb to get to that point, and for somebody fairly young in the profession, quite remarkable. I didn't want to at all cut off the panel. If there are any other comments that folks want to make before we call it even, go ahead, Victoria.
Just make one last comment, which is be persistent. Don't give up. It's tough to get in. I think everyone on the panel would agree with that. But you can do it. We got in. So just be persistent.
Great. Juan Felipe, it looks like you have a thought.
I have an idea. Really, in investment arbitration, it's a very young type of arbitration area of law, if you can call it an area of law. There is a lot to write about, and especially, I may say, there is a lot to think about. So if you find something that you think it's interesting, get that niche and get deep in that subject, write about it, read about it, talk about it, and maybe one day, who knows, they will call you and they say, we know that you are the person who knows the most about this issue here or everywhere, and we need you. So that's probably a good advice for young veterans.
That's great advice, and particularly in the investor state context, when the disputes are arising due to the acts of the state, and you need to understand what states are doing, the ramifications of it, and how it can give rise to treaty claims, and you can focus on all kinds of regulatory issues that potentially could give rise to these claims, and understanding the implications of them. I think the tribunals are at the point now where they're just at the tip of the iceberg. I don't think there's a complete comprehension of all the ramifications of these treaty obligations in relationship to the way states operate. Daniela, did you want to make a final word or two?
Thank you. Yes. Also, I think you have to take advantage of the opportunities that university gives you. For example, GW, at least from my experience, I did an internship at the IFC, starting, it was an international commercial arbitration. It was with doing business, so what we were doing was advising countries like how to amend their laws, according to other types of laws, and like giving them different perspectives on expropriation in different areas. I think GW and a lot of law schools here give you that opportunity. I mean, especially, of course for JDs and LLMs, but especially for LLMs, because you really don't have an experience outside of the local level, at least if you haven't worked somewhere else that is not your home country, and that gives you a different perspective, gives you an opportunity internationally at an international organization level, and that opened up, I think, your doors to a lot of things. I mean, and be persistent, take advantage of these things, because I know at least GW and also that American, they have a lot of opportunities with the IDB, the World Bank, and different institutions. And if you have them, I mean, pursue them, because this will give you a lot of opportunity, I mean, for your future also.
Great. Well, if the audience could please join me in thanking the panel of Daniel Aguero and Jeremy Sharp, Professor Victoria Shannon, and Juan Felipe Gonzalez. Now to enjoy
please join us to have some wine and dessert. And thank you very much for coming. Hope to see you at the next Holtzmann Center event. If you have any questions, send us an email. I have some business cards here. We also have flyers and new chairs for our upcoming conference in April. There's also an arbitration conference with the IT of ASIL. It's the first week of April, so if you're interested in learning more networking, they're going to have a lunch specifically for networking and making connections. You should definitely attend that. And feel free to visit our website for more information. Thank you so much.